Willie D. Live.
What's up, family? If it's your first time checking out the show, let me know what city, what state you're coming in from. If you're outside of the U.S., let me know what country you represent. Throw up your flag. Family, I need you to smash up the likes, smash up the likes, smash up the likes. Also, if you have not done so already on YouTube after you subscribe, there's a little bell next to your subscribe button. Go ahead and click that thing right now so you can get your notifications each time I drop a new video like this. That way you'll be in the loop. Today, family, we got attorney Yolanda Trotman, who joins me to examine something bigger than rumors or speculation. What the evidence still hasn't explained in the Nolan Wells investigation. Yeah, there's Yolanda. Hey,
Hey, Willie, how you doing?
I'm absolutely wonderful. Thank you for joining me and welcome to the show.
Thanks for having me.
Yeah, so let's get right into it. You actually posed this question on your Instagram, which is a good follow. What is your Instagram?
It's at Attorney Trotman, and then the one that has all the legal briefs in one place is All Things Legal, the number 4U, like the letter U.
Yeah, good follow, y'all. Check out. So, Yolanda, what is the biggest unanswered question you see in this case so far?
Definitely the timeline, because any type of investigation, and particularly homicide investigations, is going to be dependent on what the timeline is. And so every homicide case I've had as a defense attorney, that's the first thing that we put together. And you put that timeline together, not just by what witnesses say, because we've seen a lot of that. And when I've been covering it, I've been paying attention to that specifically. But what I do find in this era, especially in the digital era, is not just the timeline, but where the digital or the forensic evidence is going to fit along that timeline. So, for example, the GPS from the boats, the forensic examination, the examination of the phones, because I think it's important for people to know it's not just opening up the phone, unlock it, and scroll. That's not forensic. Forensic is going to give you metadata that's going to tell you when a text was sent. It's going to tell you where it was sent from, what time zone. It's going to tell you all of that information. Now, you may not, for example, get the actual text message itself because it depends on what the phone companies preserve and what they don't. This is early enough. I'm pretty sure that subpoenas or things were sent out to ask to those records to be preserved. But it's the timeline. It's going to be GPS is going to tell us. It's going to tell us where boats were, where boats weren't. But I think in particular, the metadata in terms of what's been put out by the boys' attorney is going to be especially important. The video, for example, the still shots that they have been circulating that purports to be their alibi allegedly, that's going to be especially important. I always think witness statements are important, but witness statements, identification, all of that evidence is always going to be subject to rigorous examination. But the forensic data and how you collect that, how you preserve it, I think is what's going to be the most important thing. Of course, in addition to the autopsy, because we still don't have a cause of death. And so until we have a cause of death, there's no homicide. Until there's no case number, then there's some things that are limited until it's taken to the grand jury and we see what happens from there.
Yeah. Can that digital evidence be compromised?
Yes, but the compromising issue is not the data itself, it's whether or not it's going to be admissible. There's two different things. So the data, it just says what it says, that there's no disputing that. The question is it going to have a challenge to it coming into court should there be an indictment through what we call chain of custody? Is it authentic? Can it be reproduced? Do we know where the data came from? And is that custodian of those records from that company or that corporation available to testify? It can't just be, here's the records. Like the person who is in control of those records physically has to come and testify if there's questions about that process. So that is the weeds that most people don't know about. So even if you have it, that doesn't mean it's admissible. That's just the rule of thumb. It still has to get past the rules of evidence.
Yeah, yeah. So we all know that the family said that they searched Horn Island but didn't find Nolan. So how significant is that fact legally?
It is, but I think you have to take that in the totality of for example, you're talking about an island that is, I think I lost you. Did you lose me? But an island, there we go. We still there?
Yeah, we're
But it depends on the island. It depends on currents. I mean, because there's got to be experts that talk about the currents and movement in terms of where the body was found, obviously the number of days, and then also what that means in terms of um, establishing time of death, because that's going to be one of the biggest things is not just cause of death, but time of death. And that's still going to be approximate because you have body composition, because decomposition rather, because of the water, all of those things. It's just so much. And we don't know what the investigative report says, but the fact that where he was found to me is not the bigger issue because we don't know if he was washed up. We don't know if he was somewhere else before he was we don't know if he was somewhere else and then his body was there was movement because of currents or planted. We don't know. There's just too much that we don't know, and that will obviously bear itself out. And I think that's more autopsy driven. But where he was and where his body was up until that time, we just don't have enough information. Anything at that point would be speculation.
right. Now, and I'm gonna get into a little bit more speculation here. You know, the friends uh, allegedly had boats. He had several friends who had boats. You know, should investigators establish exactly where those boats traveled?
I can't imagine they wouldn't because anybody who saw them around that time that's a part of that timeline, I can't imagine that there wouldn't be an investigation as to where those other boats, for example, in one of the purported videos, where were they and where did they go? But again, I think that comes down to, well, when was that video taken? And is that established not just by what somebody says, but does the forensic evidence support that? Because at least the reporting is that there were hundreds of boats, over 1,000 people there. So I don't think an investigation has to say where every boat is, but I think any boat that was in close proximity to the boat in question should be documented. Absolutely.
Could boat GPS and phone information, that phone data, tell us if Nolan body was already in the position that it was before it was discovered? Like, could it tell us? Could it tell us that this body was actually dumped here and it did not wash ashore?
No, unfortunately, because you would have to establish where the body was, and I think it's important to know. Let's say that it's a drowning. Let's just say that doesn't mean that there's still no foul play, right? Because what if he was hit over the head? What if his head was placed under the water? What if there was an injury? Then he was in the water and then he subsequently drowned. So just drowning in and of itself doesn't mean that there's no foul play. They would have to establish that it was accidental. And the only way you do that is to establish a timeline, um, part and parcel of witness statements, but you still have to be able to put the pieces together on the timeline. I think the body tells the story, right? So the problem is with water is that there's going to be damage that's going to damage tissues, right? Some things, for example, when people were up in arms about the initial autopsy and freaking out over missing parts, like to me, that signals that there was some concern because if the belief was it was just accidental drowning, we would have had an autopsy 3 weeks ago. Well, not quite that quickly, but we would have had a preliminary report that would have been public, all of the things. I think because the ME did remove at least those particular parts to send it off for further testing, I think signals that there was some concern. Don't know what that is because we still haven't seen it, but enough that it triggered some concern. Because I do feel like if it was clear evidence that it was an accident, we would have had that by now. But I think because there's so much that we don't know and the investigation hasn't had the transparency I think it should, given this has gotten so much national attention, here's where we are.
Yeah, and I am absolutely with you on that. If it was an accident, if that was evidence, if that was undisputable evidence that it was an accidental drowning, they would have made that, they would have made it available. They'd have made that information available like that, because that's what they do. Just like when there's a shooting or they violate somebody or whatever, and they have it on video, that video comes out in record time, like, oh, look what it, look, this is right here. And we do this in the effort to be transparent. Our men and women serve and all that. They got the whole speech ready. But when they have an illegal kill or they violate somebody, they know they're in the wrong, it takes an act of Congress to get that video footage. They will not release that video footage under any circumstances. You got to do a whole lot of stuff to get that video footage. So I absolutely agree with you there. How important is establishing Nolan's precise location to this investigation?
I think that's crucial, but again, I still think we have to establish the big question is, did he get on the boat or not? Right? That's the big question. And we still are in a space of speculation with that. We can make our natural, I think people are making their natural assumptions, but again, the speculation is not evidence. I think if he in fact got on the boat, then the movements from that point are going to be crucial. And I think less in terms of whether or not he was on the boat, but where was the boat, right? That's where the GPS coordinates of the boat, at least that we know he came on, and at least we know that we believe that the phone was left. Those coordinates, I think, are what they would ordinarily pinpoint and track where that particular boat was at the time. And I think, to me, in terms of establishing the timeline, I think that is the most crucial. Where did the boat go? Why did it go there? And we could talk all day about the CETO call, but my concern in terms of that is that there's going to be so much speculation with an enhanced audio until the actual original audio, which I understand that they've requested, is out there. That's not enhanced. I think then, that established, I think, the biggest piece of the timeline in terms of how they moved, but more importantly, why did they move the way that they moved during that time? I think the biggest wrinkle, though, honestly, Willie, is when I saw the attorney's interview on Nancy Grace, where they said, there's a couple of witnesses. What immediately caught my attention is witness identification. I don't care what state you're in, is notoriously problematic. Especially even though they've made a big issue of, oh, the island's flat, nobody could have done anything on the island. Well, nobody's really saying that it happened on the island, right? At least that's nobody's story. Because he could have been washed ashore, something could have occurred on the island. But it's these witnesses that they indicate that say that he was there or he was seen after. Oh, that's going to be a tremendous scrutiny, because even in North Carolina, where I am, and I'm sure it's true in states, there's eyewitness identification over decades has been problematic. In North Carolina, we have a whole Eyewitness Identification Reform Act that specifically details what is important and how we can suppress witness ID when it's found to be unreliable. Right. So now you're talking about somebody, what distance had the person been drinking? What did they see? What was he wearing? How do you know it's him? Couldn't be that he was the only black kid, young black male out there. Like, how do you know it was him? What's the basis? How long did it take you to identify that person? When was the statement taken? All of those things. So, that's what I'm most interested in. The people who they're saying established that he was on the island after the fact. But that's going to be interesting, depending on what happens with the grand jury.
Yolanda,
Yes.
something is telling me that you believe with all of your heart that foul play was involved. And it's hard for me to get this out of you attorneys, because y'all like, because y'all have a duty to say, hey man, let me follow the evidence. But I mean, there has been some evidence and there has been some statements that's made. I mean, as far as somebody that know this stuff, that study this stuff, I mean, this is what you do. You've been doing this, 24 years or something like that? I mean, what's your gut telling you?
Willie, you trying so hard, and I'm gonna be just like every other attorney up there. I don't know. What I'm going to say is, here's what it says. Until there is a cause of death, we just don't know. What we do know is that that doesn't sound right. That doesn't make sense. I'm not real sure about that. But we still don't have the fundamental question of what is the cause of death. We
Okay.
have to start there. And an indictment.
Okay. Let's take
Okay.
a look.
But
Okay.
okay, but I'm listening.
Let me wind the clock back. Let me wind
Okay.
back. Uh, wind the clock back. Yolanda hasn't yet decided that she wants to be a lawyer, and
Mm-hmm.
a regular citizen
Mm.
witnessing this Nolan Wells saga unfold. Now you're hearing all of these different stories of the friends who left him on this island with a mysterious girl alone on the 4th of July. They go home and uh, nobody knows what Nolan is. All of a sudden, he's reported missing. Now he's reported missing, and people are starting to point the fingers at the friends. Before the body turns up, people start going dark on the web. They start deleting their they start deleting their social media accounts. They won't talk to the family. They lawyer up. They lawyer up. You have the Ceto boat call. This is a big one right here. You hear a phone call with one of the guys that Nolan was allegedly with, Wyatt, right? You hear him on the phone with the Ceto dispatcher, and in the background, you hear what sounds like some people in distress, that commotion. It sounds like, and somebody makes the statement, "Is he dead?" And they're screaming, "Nolan, no, no." They're screaming his name, and they're saying things like, "Is he dead?" You hear that in the background. Is that type of evidence admissible to court? Because that's what you consider that circumstantial evidence. What is that?
So, two questions. So, there's a difference between what we call direct and circumstantial. Direct evidence is going to be your witness statements, all of those things, like witness statements, data, all that stuff. Your question was whether or not that's admissible. You're gonna be so frustrated with my answer because it's always it depends. Because in every case, you have to lay what we call foundation. You have to ask certain questions in order for that evidence to be admissible. For example, witness statements, the witness gets up, they testify, cross-examination, whatever. The call is different, right? Because the call, you have to get it in as authentic. You have to survive chain of custody, which is what the links of a chain, that you have to put those links together. And if the links are together, then the evidence comes in. Now, if the other wrinkle is the evidence could still come in, but I hate when this happens. The evidence could still survive chain of custody, right? It could still survive foundation. Judges will often say, well, it's admissible, but the weight of that evidence depends on the jury, right? So a jury could believe part of it, some of it, or all of it. So I think the admissibility issue of it being an authentic call, where it came from, where was it stored, who's the person that's responsible, all of those things that we don't get into the weeds about. But once it's admissible, then it's up to a jury to decide if it's believable, how much weight they give to other believable evidence. So the original call, if there's no chain of custody, that's coming in. And the question then becomes the enhancement part, because even with what you're saying, what was heard in the background, it depends on who you ask. Some people will say, I didn't hear that. Some people say, I did hear that. That's a question of fact for a jury to decide. But I think whether or not the enhanced version is going to be the expert testimony, the qualification, all this other stuff that has to be established before an enhanced version can come in, because there was always already a whole bunch of confusion about which version of the enhancement is actually valid. That's also interesting because then you also see this video I think it's a still shot. I'm not sure, but the still shot that's purported to be taken around the time of the call, which people are questioning. So that's a very long answer. The short answer is it depends, but they still have to get through the things that they're required to do to be able to get the call in. But it's still up to a jury to determine what they believe what they hear and how much weight they give to it. Does that make sense? That's a long answer.
Yeah, yeah, but it's a good answer. So, but check this out. I'm trying to make sure that the volume is straight here. They're saying that they're having trouble hearing me. You're good. You're good. Let's see. Y'all give me a thumbs up if you can hear me okay right now. I think I made a small adjustment. Let me know if you can hear me fine. Can you hear me? Give me a thumbs up if you hear me just well. Uh, thumbs up if you can hear me well. Thumbs not down if you can't. If you have still having problems. Thumbs up. Oh man, wow, that's good. That's good. Finally. Okay. I appreciate y'all. Appreciate y'all and my apologies for not having it straight out the gate. I do what I can on a small budget. Uh, so Yolanda, back to you. Uh, I know that I asked you two questions, and you decided that you would only answer the one about what was admissible. I still want to know. Take your lawyer hat off.
Willie, you trying. Honestly, if this wasn't lawyer Yolanda or Judge Yolanda, real talk. If I wasn't coming here to explain it in the way that I'm explaining it, I would feel comfortable just saying, yo, I think this or I think that.
Yeah,
My comfort level with that is that they're still not, like, for example, if they had been indicted tomorrow, I would have a whole lot more to say because I know there's indictment. I know there's an indictment. I know it, whatever information was taken before the grand jury, here's the charge. And based on what we know, this is what the charge is. This is what they have to prove, blah, blah, blah. I would have more of a comfort. I would still not say, yeah, I think they're guilty or not guilty. I would never do that because, I don't know enough. We haven't started a trial. We don't know what evidence is coming in and what is not. Any attorney's hesitation is going to be based on the fact, but we still don't have a criminal process. We still don't have a cause of death. So nobody can say, oh, I think they did it or I think they didn't do it. We don't know if a crime has occurred yet until it goes before a grand jury and the grand jury decides what to do from there. You trying though. You trying.
hey,
I respect it.
what? Let me do it like this then. What questions should the autopsy answer that the witness testimony cannot?
Great question. So the autopsy will give you cause of death. It'll give you approximate time of death, which I think is going to be tricky here. It'll tell you manner of death. It will tell you whether or not there was any any contributing factors, what we call, that contributed to his death. So, for example, the death, if they said was asphyxiation or drowning or whatever, however they decide, it will tell you what injuries are and how they relate to it. And then there'll be an ultimate determination of what the cause of death is. I think um, I think initially the second autopsy, I think, got everybody all riled up, and it should have, because it's kind of like all of a sudden you're hearing that these missing body parts, and people don't understand why there's missing body parts. But I do think that there's still going to be the completion of a second autopsy. I can't imagine that his legal team is not going to insist on that. But it's still not going to say, it's going to tell you cause, but it's not going to tell you how he got there. So even like I told you at the top of the show, like even if they say he drowned, that still doesn't mean there's no foul play. He could have been pushed in, he could have had head held underwater, choked or whatever, any number of things that could have happened to him. And even if the injury, let's say, I don't know, hypothetically, he hit his head and something happened, but somehow he got in the water. You know what I mean? So there's still a number of issues there. That just tells you that, but it doesn't tell you all the pieces along the timeline that gets you there. I think what's really going to be interesting, I don't know if we're going to get to it, is what the new attorneys have been doing as it relates to telling folks, threatening, not threatening, let me use the correct term, but the demand letter that was sent to Reverend Sharpton. Probably not the first one, probably not the only one, but I'm watching that as well in terms of what they actually do on that, because that's a risky move for them,
Mm-hmm.
for sure.
Yeah, absolutely. Let's say some of those stories conflict. Those. Let's just say any person's story conflicts with the GPS, phone, or forensics evidence. What
hmm
happens next?
Still comes in. It's still evidence. It's not like it's going to be stricken from the record or the jury is told to disregard it unless they say something completely crazy or hearsay, all of those things we hear about on TV. but a jury's going to decide how they're going to weigh it. So here's your pot of evidence. Which pieces do we believe? Which pieces do we may like not consider? And what does that mean in the basis of reasonable doubt, right? So if they, so they're going to, so if he tests, if say Bobby Jean, I don't know, I'm making up a name, Bobby Jean says this, but the evidence says that, they're not going to believe Bobby Jean. They might believe some of what Bobby Jean says, but you don't have to take a witness's statement in its entirety. You may believe some of it, part of it, none of it, all of it. Yeah.
What evidence would you want to see before the case is taken to a grand jury?
So, ordinarily I look at these cases from a defense attorney hat because that's how I started my practice. Now, from the judge hat, when I was on the bench, I'm always looking at both sides. I was never a prosecutor, but I do know that the standard is so not minimal to be able to get an indictment. There's not a whole lot that has to be put out there. So I suspect that the lead detective would test. Now, I'm just saying, you asked me what I would like to see. I'm saying, in terms of what would go before a grand jury,
Right.
because I think that's different. But going before a grand jury is likely going to be your lead detective. It's going to be your medical evidence. People think the grand jury is this big process. It's not. It's in secret. It's just enough to be able to show that there's a reasonable probability that a crime occurred. That's it. So none of the boys, for example, no specific civilian witnesses generally ever testify during a grand jury proceeding.
None
If
of the
there's
men.
a victim. Hmm?
None of the men.
I can't imagine any of the boys. I don't even
Men.
know all their names.
Men. They men. They men. 18
Oh,
plus.
you're
Men.
right. You're right. Men, young men, but men
Yeah.
nonetheless. Either way, because we don't. But I think the issue is that none of them would ordinarily testify in front of a grand jury. Say, for example, if you're the victim of a crime, you don't testify. It's the detective that testifies. It's the ME or the report that comes in because the normal rules of evidence don't apply. For example, and nor the constitutional protections. Like you don't have the right as a defendant to attend a grand jury because it's done in secret. So I would be the only thing that, and it's so rare, it's rare that a grand jury comes back with a no bill, which means that they didn't find that standard in order to indict. I think the better question is when it goes to a grand jury, what would the charges be? Who would the person, who, if anything, would be indicted? Some of these men, all of them, none of them. I can't imagine. I don't know because we don't know we don't know the totality of the evidence. We just know what we're speculating on. But I don't see a date of terms of when they're going to the grand jury. They don't typically announce that. It's just grand juries because every state's different. In North Carolina, grand juries once a week on Mondays. Other states sometimes it's once a month. Smaller counties, they may have grand jury once a month. So it just depends on how they set that up as far as when it can possibly go before a grand jury.
Yeah, yeah. What I want to know is, I want to know who was the last person to lay eyes on Nolan Wells? Who was the last confirmed person? I got to speak in these lawyer terms. See, I be talking a lot of lawyers, so I get my little lawyer terminology down. Confirmed. Who was the last confirmed person to see Nolan Wells alive? Because that would tell us a lot. If they could if they could pinpoint who that person was. But I don't think any of them want to put themselves in that position to say, "Hey, I was the last one to see him." You know, has every person's timeline been verified by the investigators? I don't think so. What have you learned?
Well, that's not anything any of us would be privy to. What the actual master timeline that we would call it, we don't know that. That's
Mhm.
going to be part of the investigative file. That's not going to be available to the public. That's going to be internal. The only way and when that would be released, in a practical standpoint, is if there's an indictment, if there's charges, it would be released to whoever's defense attorney. That would be during the discovery process. But that's not going to be released. The only thing you might see publicly is maybe like a public incident report But even then, you have to request that, and it's going to be 1 or 2 lines. It's never going to be an internal investigation. The public's not entitled to that. As much as we think we should be, we're not entitled to that because that's internal. That goes to the attorney that represents the person who's accused.
Have you yourself seen any evidence out there that can establish exactly when Nolan was separated from the group? I mean, if you're looking at the timelines, you're seeing what they're putting out there. Have you seen anything out there that has led you to believe that this is when I believe he was separated from the group?
Well, the only thing we have is what they're telling us. And there's inconsistencies in that because you have to establish, well, did he go on the boat or not?
Mhm.
Step number one. They're saying that he didn't. They're saying that he was with this other person. She's saying, no, he was not with me. I thought he was going with them. So that's all that we have before us to be able to determine that. It's just what somebody's saying. And you treat that with whatever else that's believable. I mean, everybody has kind of a lot of people have deconstructed what these boys have said. I'm sorry, what these men have said, let me be clear. But I also think, part of this is them making the decision to go public, which I would have never suggested that in a million years, because you don't talk, like, be quiet. You don't talk. Even if you're trying to get ahead of the court of public opinion, if you will, I don't think any of these interviews have been helpful to them. If anything, it raises more questions than answers. And so some of the questions that you asked me, what do I think? I was like, yeah, Willie, but the problem is like you're saying this, but it leads to this question and this question and this question. We keep going down a rabbit hole of other things, but we still don't have the core evidence that I think is important, that as much as we want it, we're just not going to get it from an internal investigation. And that doesn't really happen until we have an actual criminal process, a cause of death, and an indictment, for sure.
Okay, I asked you to put your civilian hat on. Now I want you to put your judge hat on. Let's go back to the time when you was a judge. Let's
Hmm.
say somebody walked into your courtroom and you heard the defendant deleted their social media messages right after their friend turned up missing. Would that be a cause for pause in your mind as a judge? And how much
So
how much would that weigh on your deciding to grant or deny motions?
that's a great question, but I think it's a little bit murkier than that, right? Because if this is a case that what you're talking about, let's say, assuming that it's a felony case, what I think doesn't matter because it's going before a jury, right? Like the jury is going to make all of those decisions, unless for some reason somebody wanted a bench trial, and I can't imagine how they in their right mind would do a bench trial, right? To let me as a judge sit as a jury of 12. That said, let's say there's a pretrial motion to suppress something. Um, I don't know. It's still not about what I think, it's about what the law says, right? So I have to apply the facts to whatever the current status of the case law is. And I don't know what that would be for Mississippi. I couldn't say. But like if this were maybe a bench trial, maybe a misdemeanor, of course, like I'm going to weigh that in terms of whether or not it's consistent with I don't even know what the charges would be in your scenario, but you know what I'm saying? Like it just depends. I think your general question is still going to go before a jury. In pretrial motions, what I think, my personal opinion, does not matter. That's why I'm supposed to be impartial. I'm a human. Obviously, I may have inklings, but I am supposed to be impartial. And what I'm going to look at is what's your argument? What case law do you have to support it? What facts are consistent with that case law? Or what facts are different from that case law? And I have to make my ruling based on the status of that case law, not what Judge Yolanda thinks. You see what I'm saying? So I
Right.
think people have to understand that even when you're talking about pretrial motions to suppress.
What would make investigators bring somebody back for another interview?
Oh, that could be any number of things. They didn't ask they didn't ask specific questions during the interview. They may have come across additional evidence that they didn't have at the time. Um, those would be the two general things. But if a person is a suspect and they have an attorney, most people aren't going to, or at least they shouldn't, speak to law enforcement at that stage, especially if they are a known suspect and they haven't been charged. Now, once a person's been charged, can't talk to the person without their attorney present, because now you've got a whole separate set of issues once a person has been charged and what we call Miranda, your Miranda rights attached, because there's self-incrimination, totally separate issue. But in the investigative stage, it could be any number of things. It was typically those two things. There was information that they came up with that wasn't consistent with what the witness said, or perhaps there were some gaps in the timeline, or whatever that person said that they want to fill in. But those are typically the most common reasons that a person will be asked to be brought back in for questioning.
You've been following this case closely. You've seen how law enforcement has responded to public requests to get to share information. But you've seen, I mean, you know how it go also behind scenes, just behind the scenes. Just because they're not sharing information does giving us updates does not mean there aren't updates, right? So
Correct.
But based on that, based on the way that you've been watching law enforcement move, watching the DA move in this case, do you believe that there's some motion in the ocean?
You mean that there's something funky going on between there? Is that what you're saying? Let's keep it real.
That's what I'm saying.
Okay. I can't say that one way or the other. I can't. I don't know these people. I don't know the DA. I don't know how they move. I don't know any of these people who be involved.
You know
I
Mississippi.
don't know Mississippi. I'm in North Carolina. No, I don't. I'm in
Mississippi. You can wait a minute. Now hold on. Now I got to get you, Judge London. I know damn well you know the history of Mississippi. You're a lawyer. I mean, you study law. I know you know the history of Mississippi. Okay, so let me assume you don't. Mississippi has a sordid history of black bodies popping up left and right, drownings, hangings, mysteriously black people not getting any type of justice, people being murdered in all types of ways, and nobody being held accountable. Oftentimes, these people who are turned up dead are suspected of being murdered by white folks, and nobody ever gets punished for these killings. Most of the time, these people turn up dead. It doesn't matter if they are found hanging with broken legs. They'll call it a suicide. I don't even believe that in the last 100 years or so that a hanging in Mississippi has been deemed a homicide. That's Mississippi's history. Now, what do you say to that?
So as a historian, I never said that. What I am saying is that your question was specific to this investigation. So be fair, Willie, be fair. You said, is there something funky going on with this investigation? I said, I don't know these people. Me knowing Mississippi has nothing to do with the dynamic between the DA's office and all of these other people and how they move. What I will say, I'm gonna push back for a second. I do think 100% if Nolan Wells' death, regardless, had not picked up this national attention, I do feel like that the fact that it's gotten this much attention and interest has done nothing but amplify and make any investigation tread lightly. You have to dot your I's. You have to cross your T's, because if it turns out that data and things that they should have gotten and they didn't get, then that's where I think the beauty in all of this is set. And as horrific as this situation has been, what I am so glad to see is that so many people are still invested in Nolan Wells's truth, like the truth of what actually happened to him. A direct answer to your question, do I think something's funky going on in investigation? I don't know. Nobody has the investigative report. Really, don't look at me like that. Nobody has the report. For all we know, they've gotten all of the data. People need to understand that just getting GPS data takes time. I've had a homicide where I don't get the GPS data 9 months later. And it's not like nobody asked for it. It's just that takes time. Phone dumps it's not like it is on TV. You plug up a phone, you got a phone dump the next day. How you see on TV, oh, we got all the records. No, you don't. That's on TV. Like, phone dumps take time. I do think that there's issues that people should be concerned about, especially, for example, this joint examination of the phone that there seems to be an issue with in terms of getting it done and all the media that's surrounding it. But your direct question is not a fair question for me to ask because I don't know what's in the investigative file. Nobody does. I don't know what the status is of their investigation. I know it's ongoing, and the things that I think that are crucial, which is this the forensic information that they need. I am confident they probably don't even have it all yet. Pretty confident in that, and just in the length of time that it takes. But I
Okay.
think putting all gas, no brakes on this and still talking about it and people still asking those questions, I do think is crucially important that people don't give up on finding the truth in terms of what happened to Nolan.
Okay. All right. Okay. You got me. That's fair. That's fair.
Thank you.
But here's the thing, though. Can circumstantial evidence be enough without a smoking gun?
Yes, it depends. This is always going to frustrate you and your viewers. I'm telling you, the lawyer answer is always going to be it depends. Really, anybody watching, well, what's that mean? It's always going to be because
Yeah.
no case is the same, right?
Right.
Circumstantial evidence. It depends on how I don't know how their jury instructions are written. Yes, circumstantial evidence can be enough. It just is different from direct evidence like witness statements, weapon, murder weapon, all of that. Can circum can circumstantial evidence convict? Yes, but it's not going to be in most cases by itself because there's going to be direct evidence that comes along with it, right? So the way most people say, best way to understand circumstantial evidence, somebody says it rained outside. You don't know it rained outside, but you went outside and the street was wet. Well, the street got wet some kind of way, it must have rained. So that's a good way of understanding circumstantial evidence. Here's the end result. We didn't see the rain, but we went outside and my grass was wet and the street was wet and the sidewalk was wet. It had to get wet some kind of way. That's the difference. So when you think of it in those terms, yes, it can, but it has to be along with, for example, the weather report. What did the meteorologist say? What did the radar data say? You see what I'm saying? So getting to the end result is one thing, but also understanding that circumstantial evidence by itself is not likely to convict in most cases, especially if there's no direct evidence to support it.
See, family, this is why we bring the experts on because, you know, I just be thinking like, man, look, man, hey, man, he did this, he did that. Hey, man, you got to go to jail. Like, get him. Like he wrong. Like so they break it down. They look at it from a legal standpoint, and then so that's important. Uh, we've been talking about, and we started this off, with talking about how the biggest, we heard the evidence, a lot of evidence that have answered certain questions, but it's the unanswered questions are the biggest piece of the puzzle here for you, and I think for everybody else. So what I want to know is, what unanswered question would you need answered? Which one would concern you most before presenting this to a grand jury?
As far as evidence or lack of, I'm not asking you a
Yeah,
question again. I'm not sure.
what unanswered question? What unanswered question would concern you the most if you were presenting this to a grand jury?
I think um, if there's gaps in the timeline, because I told you at the beginning, I think the timeline is the most important thing because the timeline is going to establish who, what, where, when. The why, motive, all of those things, depending on what the person's charged with, are also things that a prosecutor is going to have to think about in determining what they're asking the grand jury to indict on. That's a whole separate conversation for another day. But I would say if there's gaps in the timeline, possible motive, opportunity, that type of thing, depending on what charge it is that they may be seeking. But again, that's also wrapped up in the autopsy. And I think, you know, I'll leave it at that.
Yeah, yeah. Okay. Let me ask you this. Let's say the men who were on the boat during the Ceto call, let's say these guys were all questioned and they provided different stories. Each one of them had a different story. Do we have enough to go to the grand jury just based off of that?
I don't know. I think the frustration I think that people have, and I understand the frustration. You have to understand is that we don't know what is going to we don't know what the investigative file has, what it doesn't have, right? All people can do is speculate. And I think the problem that I see when I see people getting upset in terms of the process, do I think it's taking a long time to indict? I just don't think so. I really genuinely don't think so. I think part of it is because we don't know where he was. We don't know how his body got there. We don't know all of those things. Just because someone believes that there's foul play, you still have to be able to determine, okay, even if that's the case, then what charge do we go after? Do we go after the top count, which is first degree murder? Do we go after voluntary slaughter? Do we go for an involuntary manslaughter? Like, what is it that we go for? And you have to at least have a theory, and you have to have a timeline. So people who are upset that we just, there's enough, but you still have to have a theory. Even if, for example, people felt like, well, it was intentional and it should be first degree. You have to prove premeditation. You have to prove deliberation versus something else that's a lesser included offense. What you have to prove is different. The worst thing that this DA can do is go in here and overcharge, and get an indictment for something that he or she, I believe she knows that she can't sustain in front of a jury. Because getting an indictment is one thing, getting a conviction is completely different because of reasonable doubt, and the standard is very different. So people who are upset and frustrated, I understand that. I completely understand that. I always look at cases, from both sides, but I'm a defense attorney, right? But I do believe that the issue is not just the theory. Here's the evidence. Here's what we can prove. Here's what we think will make it past a jury. Because otherwise, Nolan's family gets no justice. If they overcharge it and if they can't get a conviction with the jury, he still has no justice. If they undercharge it, that's a completely separate issue because they can always do a superseding indictment. So you may indict on one thing. If more evidence and things come out and it's a higher count, they can always go back and do a superseding indictment. But that's a part of the process.
To your point, you just had me thinking about this other case with David. You know the singer David, the young man who was he's a singer, a rapper singer. He was accused of killing his underage girlfriend. I think he was like around 19. She was like 14 or something like that. But he's on trial right now. They found her body chopped up in the back of his Tesla truck while he was on tour.
Oh, I'm not familiar with the case. I'm
Yeah,
sorry.
they found his body, well, not in the back, but in the front because the trunk is in the front. So in the trunk of his Tesla vehicle while he was on tour. And it took months for them to serve him with an indictment. Months. So I get it. And it looked like from the first time I saw the case, I was like, yeah, he guilty. Like he did that. Because it was so much circumstances that was leading directly to him. I mean, they first of all, they found her body in his trunk, in the trunk of his vehicle. They went to they talked to friends who said, hey, he visited the desert. He went out to the desert in the middle of the night for this or that or whatever. Then they found pictures, and then they found notes, and there was evidence of violence. They was fighting and all kinds of stuff. So I was like, yeah, he did it. He did it. And so right now he's on trial for murder. It took them months to bring an indictment to that, and I know that the parents and the public was really frustrated about that because for a while it seemed like they was just going to let him slide. It looked like they was just going to let him make it, but it looks like they in there right now and they're trying to finish him off. But who knows? I mean, it's the United States judicial system, and everything ain't always what it seems. Just when you think you got it like this, something else happens. I'm sure you've had cases where you thought that the prosecutor had them, and next thing you know, the defense turn it all the way around, or the defense looked like they had it and the prosecutor turned it around and it came out a different way. That's the, I guess that's the, I was about to say the beauty, but like since we be getting the short end of the stick so much, I can't find anything too beautiful in this judicial system. But I digress. I do thank you for coming on the show. And are there any parting words? Anything what do we need to know about this case that that you know and that you want to tell us, because we act like we know what's going on, and I'm sure by you being a legal expert, it frustrates you sometimes when you see people saying certain things about a case like this, and you know that they're way off. What is it? What is the biggest misconception that we have about the legal system? Us
That is
laymen's.
quick. I think that is quick. It's
That
not.
is
That it
okay.
is quick. That I think because TV sensationalizes the system in such a way that people think, okay, this happened, and now all of a sudden we have a trial. I think the fact that there's been that people think that indictments and investigations should be quick in this digital age, that's just not true. The process to get items, for example, pre pre indictment is very different than when you have a case number, for example, that you can actually subpoena records. And I think the fact that people are frustrated assuming that what hasn't been done, and you don't know what's been done. Like, we're not entitled to the investigative record. We're not. We're not entitled to know everything that's going on within an investigation. We're not. We're not entitled to set a timeline in terms of for what how quickly a DA indicts. Even in the case that you raised, it took months, even with evidence that seemed to be so easy and let's go ahead and get it done, but it took months. um I think that people want to have, and they deserve to have, some transparency though. I think people want and deserve to have at least some sense that the process is moving along. I think one of the things that has been problematic, and I've said this, is that you had a statement from a law enforcement officer at the very beginning that suggested that it was accidental before you even had a medical examiner report. And then we don't hear anything for a couple of weeks, and then we finally know, we hear all this confusion and chaos over an autopsy. And I think with something that's gained this national attention, what you would expect to see is that at least somebody saying the basic things. There's an investigation. If you have information provided, we're going to make sure that there's no stone left unturned. All of those things haven't happened. So it amps up people because we don't know. But I think the biggest thing I would tell people is the process is not quick. Average homicide trials, even after indictment, take years with an S. That getting information takes months with an S. And so as much as we want to have instant answers, that's just not how the system works. And for me, I think people be calm. We want them to get it right. Everybody say, oh, nothing's going to happen. Nothing's going to happen. We want them to get it right, because if we don't, Nolan's story doesn't get told. Nolan doesn't get justice. We don't get the truth. The more the hurry up, hurry up, hurry up does not do his legacy it does his legacy a disservice. And I would just ask people to be patient. I would much rather the time be taken for them to get it right than to over indict, and then they get it wrong. We go to trial and he still doesn't get justice. That's what
Uh,
I would say.
Man, that is some extremely good information and advice. Okay, I'll keep that in mind going forward.
That's all I ask. That's all I ask, Willie. But
ladies,
yeah,
ladies and gentlemen, Yolanda Trotman in the building. Yes, yes, y'all. Hey, I appreciate you. Hold on now,
appreciate
because
you.
I want to speak to you off camera.
Sounds
Okay.
good. Bye, y'all.
So let's go in here real quickly and see what y'all saying. Let's see what y'all talking about. Somebody's let's see. What we got? What we got? What we got? What we got? So we got to keep that in mind. That's very that's some strong advice right there, fam. Strong information and advice. Like, it's not quick, and we don't want to try to rush to judgment so fast that you over indict, you overcharge, you over indict, and then next thing uh, the family still don't get justice. So we want to make sure that it's done right. But some updates would help. Give us a little, throw us a little bone every now and then. Let us know you're working on the case, because as far as we know, the district attorney then went on vacation. Okay, let's see. EZQ Universe. Quad, what up? Robert, I see you. James R. Azure. Solo Empire. Stay prayed up. Antoine, what it do? What's up with you? Who's that? Talia Matthews. What's up, Talia? Nicole, I see you. Matt Kinley Webb. Yeah. Let's see. Divinely blessed. Miss Pinky. That's my time, fam. I appreciate y'all joining live. Until next time, enjoy the rest of your morning, afternoon, or evening, wherever you are in the world. No more talk.